Ohio State University, and he holds a joint appointment at both the law school and also the College of Public Health. His scholarship primarily examines the intersection between public health research and legal doctrine with a focus on tobacco policy. Along with teaching, he also has worked to inform public health policy development on a federal level, serving as an advisor to the FDA for tobacco products and as a member of the National Institutes of Health Council Public Representatives. Today is going to talk about the lessons learned from the tobacco settlement and how we can use those lessons going forward with a possible opioid settlement.
All right, thank you. And that was a great, it's good that we put these two presentations together. I think they'll really flow from one to the other. In fact, Professor Weeks and I probably should talk before making our presentations, because you'll see I have some similar slides. So it's good though. It means I'll get through this one a little faster and hopefully have some time for questions and discussion. So I'm going to talk about using opioid settlement proceeds for public health lessons from the tobacco experience. Just sort of a preliminary point that I think is important to make before I get going is that I get asked all the time about sort of lessons that we can learn from tobacco control policy, and oftentimes the sort of subtext of that question is that tobacco is an issue that we've sort of fixed, and we have good lessons that we can now take from that issue and apply to others. And so I just wanted to make the point that we've made a lot of progress in tobacco control, but it's only a partial success at best. There is still a long way to go. Smoking rates have gone down. They're still going down a little bit every year, which is good. But smoking is still by far the leading cause of preventable death in the U.S. Smoking kills an estimated 485,000 people in this country every single year, almost 500,000 people every year. That equates to about more than 1,300 people every single day. So it's a very different issue, obviously, than opioids. The diseases and deaths are caused and happen in a different way. But if you sort of step back and look at the big picture, there are more deaths from tobacco use every single year than there have been opioid deaths from the year 2000 until now. I think we are appropriately paying a lot of attention to the opioid epidemic, but the continuing ongoing costs relating to tobacco use can sort of get lost in the mix. So I think we need to keep that in mind as well. So that's all to say that we can certainly learn from the progress of tobacco control, but we can also learn from some of the failures of tobacco control, and I think that's sort of more what I'm going to talk about today is places where we could have done better. So more specifically, I'm going to talk about what we can learn from the tobacco MSA, which is the Master Settlement Agreement, which was a settlement between state attorneys general and the major cigarette companies in 1998, and I'll get back to the MSA and what exactly it said in a minute. So I get asked this question all the time too: what can we learn from the Tobacco Settlement Agreement? And so I sort of looked, and surprisingly, no one has written a lot on that topic yet. There's this article by Derek Carr, Corey Davis, and Lady Rucko in Public Health Reports that gets into that a little bit, and they basically conclude that the odds of any settlement money from an opioid settlement getting spent on public health is pretty small. And that's probably true. I'll maybe try to be a little more optimistic about what we can do with some of that money. But there's been sort of other short commentary-like pieces like this in some of the public health literature, but no one's really done an in-depth treatment of the issue. So I'm sort of grateful to the Kansas Law Review for giving me the opportunity to do that and to dive in a little more on what we can learn from that experience. So another just sort of quick caveat is that this is a separate question from the bigger picture question of what can we learn from tobacco regulation and apply to opioid regulation generally. That's a bigger topic. I'm happy to dive into that. If we've got time in the question and answer, we can talk about that a little bit more. But for purposes of this presentation, this paper, I'm going to focus in a little more specifically on the lessons from the experience of the settlement agreement, and even within that topic, focus on where the money went and how the money got used by the state. So, outline, just a little background on opioid litigation, which you've already heard, so I'll go through that quickly. Then the tobacco settlement agreement and what it did, what happened to the money, and then what we can take from that going forward. For sort of points 2 and 3, the settlement agreement and what happened to the money, I'm going to give you a little bit of my personal history because I sort of lived through that in Ohio and how Ohio used its money, so I'm going to focus a little more specifically on what Ohio did, and because I actually think it's a pretty good example of what happened in a number of other states as well. So here's Judge Bolster again. Every picture of him, he looks a little bit sad. He's got a tough job. So I won't spend a lot of time on this. You already heard he's overseeing this multi-district litigation panel, 400 or more than 400 lawsuits. Legally, these are complex cases, and they're different from the tobacco cases and probably more challenging than the tobacco cases. I won't go into that, but the quote that Professor Weeks put up, he said, no one's interested in these legal questions, but I'm interested in those legal questions. I think those are really fascinating legal questions that we don't necessarily know the answer to. The tobacco cases settled without going to trial, so some of those similar issues were raised in the tobacco cases, and we never really got answers to some of those important questions about preemption and some federal courts issues of the intersection of federal law and state law. So there's interesting issues there. And then the other thing is Judge Bolster is pushing, as you heard, really quickly. I mean, he said he wanted to settle this in 2018, which is not going to happen. But he says we don't really need this whole long drawn-out thing. We just need to knock some heads together and settle it. And I think the experience of the tobacco litigation would suggest that that's not necessarily a great idea. The reason that those cases settled was in part because there had been litigation and discovery, and the more the documents came out, the better the picture the public got of what the tobacco industry knew and when they knew it. And one of the outcomes of the settlement agreement was actually a requirement for them to disclose all of their documents that weren't covered by privilege. And that trove of documents has been extremely important for tobacco control moving forward, to understand how the industry operated, how it sort of still operates in some ways. And that could have been lost by pushing too quickly for a settlement agreement and settling too quickly. All right, so in any event, there are settlement discussions going on. They're confidential, so we don't actually know how much progress they're making in those settlement agreements. There's an order that prevents people involved in those settlement agreements from talking about it. But as was mentioned, the initial trials have now been pushed to September of 2019. I think it's likely that as that date gets closer, the pressure for a settlement will increase. It's also theoretically possible that those trials would happen. I think some of the defendants feel pretty strongly that they do have solid defenses. On the other hand, the risk of actually losing that is so intense that it's probably likely there will be a settlement before that happens. This you already saw of the MTL plaintiffs. Just want to add to that, I think Professor Weeks mentioned it, but just want to emphasize there are a whole, probably hundreds more cases that are filed in state courts around the country, including here you see there's only a limited number of state attorneys general that have their state litigation as part of the MTL, but there are a number of other states that have filed state lawsuits against these same or overlapping defendants in state court. New York City filed in state courts. So some other big jurisdictions are in state courts. Ohio filed its litigation in actually 2 separate cases, one against manufacturers, one against distributors, in state court. So there are those cases going on. Then separately, apart from any of those lawsuits, there's also a collection of 41 state attorneys generals who've been discussing conducting an investigation of opioid manufacturers and have subpoenaed documents from those companies as well. So there's that investigation going on. So what is going to happen out of this? We don't know, but what's most likely to happen is that any settlement, and it'll probably be coming from Judge Polster at the MDL, any settlement that comes out of that will probably be something like a global settlement that will sweep in a lot of parties and a lot of cases that are not actually part of that MDL right now, and it's almost a given that the major defendants will insist on that as part of any settlement. Judge Polster has been operating under that assumption, so state attorneys general who are not actually part of the MDL have been participating in settlement agreements, settlement negotiations, with sort of the assumption that any settlement will be a global settlement, somewhat like the tobacco settlement, although, as you heard, it gets a lot messier with cities and counties being involved, and how the money is going to be distributed, given that is, there's just a lot of uncertainty. How much would a settlement be? There aren't a lot of estimates out there. The only one that I've seen that's really out there is by Bloomberg Intelligence, which suggests that a settlement is likely to have, they sort of said the upper bound is likely to be about $50 million. I think they said 30 to 50 is what they were projecting. That sounds like a lot of money, but it probably isn't. Once you actually divide that up between all the different states and counties and cities, that is probably not a lot of money compared to the costs of this epidemic. I should also say you're probably taking $10 billion or more off the top of the lawyers. So that leaves you with $40 billion at the upper end. And as I said, it's probably not a lot related to the cost. On the other hand, you're not going to have a settlement if it's just more than can actually be paid by those companies. So that's the tension. What worries me from sort of a public health perspective is that if you think about who has an incentive to settle and settle relatively quickly, it's pretty much everybody. The governmental plaintiffs want to get paid. They want money out of this. When you're talking about elected representatives, they want to get paid on their watch so that they can take credit for it. And they are dealing with very real costs and real losses that they do want reimbursed. So they have an incentive to want to get paid now. Plaintiffs' attorneys certainly want to get paid now. They, as we said, the plaintiffs' attorneys are basically operating on contingency. They're not getting paid unless money comes in. So they probably don't want the risk of taking this to trial. They want to get paid. And they stand to have a pretty huge payday if there's a $1 billion settlement. And defendants, assuming that it's a global settlement that brings in enough players, they want to have the legal threat behind them and be able to tell their investors that the major legal threats are behind them. So they certainly have an incentive to settle quickly. So everyone has an incentive to settle. Of those players, nobody really has an incentive to consider public health as part of that settlement. They all have an incentive from the plaintiff side. They have an incentive for the dollar amount to be as high as they can get in the settlement, but for actually spending that money on public health, it is not necessarily in their interest to want that. You have a question?
Yeah. The defendant's incentive to settle.
Yep.
Because this is not a class and can't be a class, how can defendants buy themselves global peace? And it would seem to me the defendants would only settle if they have some assurance that at least the bulk of their exposure can be settled.
Yeah, so that's right. So they are not going to settle all of the sort of individual or class lawsuits as part of this. But if it can be a global enough settlement that sweeps in enough of the states and other jurisdictions, they can potentially put their sort of governmental related exposure behind them. And that would itself be a huge, huge benefit to those companies. So that's what I've been talking about. But you're right, it wouldn't actually put all of their legal exposure behind them. The just sort of quick caveat is that the tobacco companies, or quick sort of note, tobacco companies tried to do that in the tobacco settlement agreement. They tried to not only settle all the state lawsuits, but also make it more difficult, if not impossible, for private plaintiffs to bring lawsuits against them also. The challenge with doing that is that in order to do that, they needed congressional approval. They would need an actual legislation to make that happen. And so they actually came up with a draft settlement and brought it to Congress. Congress never passed it, and so they then went back to the negotiating table and ended up with a master settlement agreement that didn't protect their exposure on that side. But it was still, especially because for the tobacco companies as well as the drug companies here, they have good arguments, and the history so far has been that they can fight off those types of lawsuits. Their main exposure that they're worried about now is the public states. Okay, so that's the quick background. Tobacco settlement agreement. So background on that. The settlement was signed in November 1998, so it's almost exactly 20 years ago. Those of you who are law students, I don't want to know how old you were in 1998, but I'm guessing probably preschool. This is one of those topics where I think the settlement agreement used to be something that people were sort of generally familiar with, and now it's sort of receding into history. And I at least find that most of my students have very little, if any, knowledge of the settlement agreement. So these are you can see that, the state attorney generals who led the negotiations. I just find this picture hilarious. They're just trying to look tough. So this is, right here, this is Richard Blumenthal, who's the senator from Connecticut. He's sort of the only one of those plaintiffs who's still active in the political arena. Michael Moore, who's right here in the front, he was the attorney general in Mississippi, and he was the one, along with Dickie Scruggs, who was the private plaintiff's attorney. They took Dickie Scruggs' private plane and they flew around from state to state to sign up all of the other attorneys general to be a part of this lawsuit. And eventually they did. Every state eventually sued the tobacco industry, and the basic premise was that they were suing to recover money that they had spent through Medicaid and other costs related to smoke-related illnesses. So 4 states, Mississippi being one of them, settled on their own, just as an individual state in 1997. And then in 1998, there was the Master Settlement Agreement where the remaining 46 states settled with the tobacco industry, as did DC and a number of territories as well. So they settled with the 4 major cigarette companies. Now those, because of mergers, now there's really 2 major cigarette companies in the country, but it was the 4 major players settled. And what the agreement provided for was money, $206 billion paid to the states over 25 years. It was, and I think it still is, the largest settlement in terms of dollar value in the history of civil litigation in the country. So 25 years is roughly from 2000 to 2025, so we're still in the middle of that period, not the middle, but we're still in that period. Well over $100 billion has already been paid out. Those payments actually, even though it was sort of calculated over 25 years, those payments keep going forever. It's based on, after those 25 years, it's based on cigarette sales. So as long as there are cigarettes still being sold, there are payments that will continue to be made to the states, and those payments keep going on and on. There are conduct restrictions in that agreement, significant restrictions on tobacco marketing, prohibiting billboards, limiting sponsorships, prohibiting advertising in youth-oriented magazines, that sort of thing. Industry document disclosure that I already mentioned. An important thing to note here is that there was $1.7 billion of the payments went to create the National Foundation that was called the American Legacy Foundation. Now it's changed its name to be called the Truth Initiative. It sponsors, it pays for the anti-smoking advertising campaigns that you may have seen on TV from time to time, especially if you're watching shows oriented towards adolescents. That's where they try to target their ads. I just highlighted that because that was $1.7 billion, which is a small amount of the total cost. But in terms of public health impact, probably the most important thing that came out of that settlement agreement. There's very clear evidence that those Truth Initiative campaigns have played a significant role in reducing youth smoking. Evidence on everything else in terms of its effect on smoking is pretty limited. And then, as you would expect from a settlement agreement, the states waive their ability to sue the tobacco industry in the future. So even though there are still plenty of smoke-related costs that states are incurring, they can go back and sue these companies again. So in the agreement, there were lots of whereas clauses at the beginning, like you see in legal documents, and those clauses made it pretty clear that the money was at least in part to be spent for advancing public health, you can see the quote here that it was for policies designed to reduce youth smoking, promote public health, etc. But that was in the whereas clauses. The actual agreement itself did not put any limitations on how the states could spend the money. Nothing required any of the money to actually be spent on public health. So you can find, and it's been pretty well documented, you can find statements from all of these different attorneys generals, all of the governors at the time, committing that they were going to spend some of the money on public health and smoking prevention, smoking cessation, but it was not actually part of the agreement. At least some of the attorneys general at the time said that the reason it was not in the agreement was because they didn't think that legally they could make it part of the agreement, because when a state receives money, it is the job and the authority of the legislature to decide how that money gets spent, and the state attorney general couldn't sort of force the legislature to spend money in a particular way. Others, by the way, said that they didn't include it because they didn't want to include it. That the governors and legislators didn't want them to restrict how the money could be spent. So I actually think that that's a really messy and interesting legal issue that has not fully been explored either. So any law students are looking for very difficult law review notes to write. I think that question of to what degree state attorney generals could require the money to be spent in a certain way through a settlement agreement is somewhat of an open question, and probably a state constitutional law question that varies by state, as I'll talk about in a second. So, and I think it's important to note it's perfectly reasonable that a lot or even most of the money from the settlement agreement did not go towards public health because it was a cost reimbursement lawsuit. So in theory, all these governments had spent money on smoke-related diseases that otherwise they would have spent on other stuff. Once they get that money back, it's perfectly reasonable for them to spend money on that other stuff that they can now spend it on. On the other hand, they waive their right to bring future lawsuits. So unless they are using the money to address future tobacco-related costs, it's a massive lost opportunity because you're going to still incur those costs in the future, but not be able to recover for them. And I think the same is likely to be true of any opioid settlement agreement. That there's probably going to be limited legal requirement to spend it on public health, but unless they do, there's going to be costs that keep accumulating in the future that we aren't going to have money for. So, what happened to the money? The short answer is that it got spent on pretty much everything else. This is just the 2018 numbers of what states brought in. This is actually tobacco settlement money and tobacco taxes. States this past year received $27.4 billion. $3.3 billion is what the CDC recommends that ideally they would spend on tobacco prevention and cessation. 726 million is what all 50 states together actually spent on tobacco prevention in 2018. The overall about 1.5% of settlement agreement dollars have been spent on tobacco prevention and cessation. A little more was spent in the beginning, and then it quickly trailed off. And that's where we are now. So let me tell you the story of Ohio to give you an example of what that actually looked like. So Ohio, under the settlement agreement over those first 25 years, is scheduled to receive about $10 billion. So Ohio, after the agreement was signed, the Attorney General at the time brought together a bunch of state leaders and said, all right, we've got this big pot of money coming in, how should we spend it? They all sat down, they worked out a plan, it turned into legislation, the legislation passed overwhelmingly, and what that legislation said is that most of the money will go into the state general fund, which as I said is understandable, but we will set aside some of the money for particular purposes. They created a bunch of different trust funds to set aside different portions of the money. The biggest of those trust funds was for tobacco prevention and cessation. And the idea was that that trust fund would get payments that were scheduled in that legislation that would add up to $1.26 billion through 2012. So from 2000 to 2012, there would be annual payments. Once they had $1.26 billion in that trust fund, they would have enough to basically operate as a foundation. And they would run in perpetuity off of the income, the return from what they had in trust. And they would never need any legislative support after that again. That was the plan. What actually happened is the first payment was made in 2001. It was a $330 million payment. They sort of front-loaded it a little bit to get them up and running. So they got a $330 million payment, got up and running in 2002. After that, in every single year after that, when it was time for the legislature to make the payment, they said, actually, no, we're going to take that money and put it somewhere else. So they got their first payment, and then after that, they never got another payment again. So nonetheless, they had a good amount of money to work with. They got up and running. They spent about $40 million a year on tobacco prevention and cessation. They followed best practices guidance from the CDC in doing it. Between 2002 and 2008, I think in large part due to that foundation, its efforts, the smoking rate in Ohio, the adult smoking rate went down by more than 12%. High school smoking rates went down by 38%. Middle school smoking rates went down by 47%. So really sort of impressive results. The sort of personal note here is that another thing they did, which I thought was really important, and it's actually had lasting effect, is that they funded, and this is actually part of CDC best practices, they funded local coalitions around the state to work on tobacco policy. So they funded all these coalitions to work on, really their top priority was smoke-free policies and smoke-free laws, getting laws passed at the local level to prohibit smoking in bars and restaurants and other workplaces. Those coalitions started doing that. They realized pretty quickly that they had no idea what they were doing. They were sort of good public health educators who didn't know a lot about passing laws. And they had a lot of questions. And so the foundation decided to create a center to provide policy and legal support for them. So they created the Ohio Tobacco Public Policy Center. I was hired in 2005 to direct that center and get it up and running. And so I have the privilege of working with all of these communities across Ohio. That sort of fed into the broader state effort. In 2007, Ohio passed, it was actually the first state that was not on one coast or the other coast that passed a statewide smoke-free law prohibiting, comprehensive smoke-free law prohibiting smoking in workplaces statewide. So that's sort of where I came into it. So money got diverted. 2007, we sort of saw the beginning of the financial downturn, and the state decided to go beyond just diverting the payments, and they securitized future settlement agreement payments. So what that means is essentially they sold bonds based on the future stream of revenue that would come in from the settlement agreement. So they got a huge upfront payment of about $5 billion, which is about half of what they otherwise would have gotten. And now, well, they got about $5 billion. They quickly spent it on a financial stimulus package. Most of it went to school construction, actually. But now it means that payments are still coming in, but Ohio does not actually keep any of that money because it comes in and then goes right out the door to bondholders. About 20 states or so have securitized some or all of their settlement payments. That was 2007. 2008, state went one further, and the economy got even worse. The governor and the legislature went to the Ohio Tobacco Prevention Foundation and said, hey, we see you still have a couple $100 million in your bank account. We sort of have a financial emergency going on here. Would you mind giving that back? And the foundation said, yes, we would mind. We do not want to do that. Based on our limited history with you, you guys are not very trustworthy. So we are not going to give back this couple $100 million. Legally, you have no entitlement to it. The legislation is pretty clear. It's ours now. So you can't have it back. And the governor and the legislature said, well, if you're not going to give it back to us, we will just shut you down. And that's what they did. So they shut down that foundation, and the money is gone. Ohio now has a kind of small tobacco prevention office within its Department of Health that does run on annual appropriations. It is just a very, very small shadow of what the Ohio Tobacco Prevention Foundation was able to do when it was operating. And you see the smoking rates either stop going down or in some cases go back up after that foundation went away. So I think it's important to note the 2000 legislation was passed overwhelmingly in a bipartisan fashion. The 2008 legislation that dismantled the foundation was also passed overwhelmingly in a bipartisan fashion. And so I think the lesson is that even with sort of well-laid plans and a good framework of how you're going to spend the money, you can't count on a future legislature to stand by that plan. So I think that's an important lesson as you think about how to spend any opioid-related settlement proceeds. So just quickly, because we're running short on time, Ohio, as I said, is pretty typical. It actually did better than most states in at least spending some of the money for some period of time on tobacco prevention and cessation. There have been a lot of sort of similar stories, and I'll go into this in the article, of similar efforts by other states to secure some of the money for public health use. Just quickly, some interesting examples of that. Mississippi was actually one of the states that settled separately in 1997. They did try to write it into the settlement agreement. So under the settlement agreement, they just said a portion of this money will be set aside. We know that it's not my job as Attorney General to decide how the money is going to be spent, so the money will be set aside. The court will hold on to it. The legislature will come up with a plan for how to spend the money on tobacco prevention and cessation, and then the court will release the money to the legislature. The legislature did not like that idea, so the legislature and the governor basically appealed it up to the state Supreme Court, and the state Supreme Court said, based on state law grounds, that the Attorney General couldn't do that in the settlement agreement. So that is the one data point we have on state constitutional law, whether the Attorney General could actually ensure that the settlement money is spent on public health. The answer to that is no. But that's just Mississippi law, so it could be different in other states. North Dakota followed sort of a similar trajectory. They spent money from the settlement agreement for a couple of years. They stopped spending it. Public health advocates in the state said, well, let's do something about this. And so they gathered signatures, got an initiated statute passed that created this Breathe North Dakota program. They spent at CDC recommended levels, cut smoking rates in half. Tremendously successful program, but because it was an initiated statute, the legislature could also overturn it with a different statute, and so they did in just last year, and so that program is going now too. So that's all very depressing. The one bright spot, so the one state that has actually been able to make sure that settlement agreement money is spent on public health is, perhaps surprisingly, Florida. Anybody guess Florida? So Florida, same thing. They used some settlement money for tobacco prevention cessation, stopped doing it. Public health advocates in the state said, let's do something about this, but unlike in North Dakota, they decided to gather signatures for a constitutional amendment. And so most states, that is not, you can't even do that in all states, but states where you can do it, it's more difficult than an initiated statute usually. Requires more signatures, more money, but they put together a campaign, they did it, passed in 2006 with 61% of the vote, and what it requires is 15% of the amount received from the settlement each year, which is approximately $60 million, has to be spent on youth tobacco prevention, and what has happened to youth smoking in Florida is that. So Florida, not to pick on Florida, but surprisingly, has the lowest youth smoking rate in the entire country, which no one guesses. And it's because of this constitutional amendment and the program that they've been able to put together because of that. And, you know, we don't, so that's sort of the one example that has worked. Other states have similarly used, well, what actually just happened last year is California passed a constitutional amendment to raise the tobacco tax and set aside some of the money for tobacco prevention. That just happened, so we don't have the result from that yet, but I suspect you will see something similar. So that's a more specific lesson, but I think the lesson is the only way to make sure that the money is spent on public health is to actually lock it up so that it has to be spent on public health. So, real quickly on lessons learned, that sort of good intentions and verbal promises are not enough. You really need to lock up the money. The fact that your program has been successful is not enough. There are lots of examples where programs were successful and then dismantled, so that it's more than that. So the only things that really seem to work are creating a national foundation, like the Truth Initiative, and so Wendy Parmet and Leo Valetsky at Northeastern have been doing some research on this and trying to get some information in front of Judge Bolster to suggest that some good chunk of the money should be spent in this way. That it should go to some sort of national foundation that could in theory even funnel some money back to the states after that, but that sort of takes it out of the state-based political process, and that would be one way to protect some of the money. The other way would be doing constitutional amendment, but constitutional amendments can be extremely expensive, and so you need to find money to do that campaign. I don't necessarily know who the motivated funder would be to put up that money. I don't necessarily know that, depending on how you frame it, I don't know that there's a motivated opposition either. So if you did find the money, I think you could get it done. But you need to get the money from somewhere. So this is actually the conversation I've been having in Ohio, is trying to reach out to people and figure out if we can put together a team of people to pull together that money and put together that campaign. Because when there is a settlement that happens, there's going to be a lot of people who have ideas about how that money should be spent. So if public health wants to make its claim, and even if particularly if it wants to make its claim more aggressively by pushing for a constitutional amendment or something like that, the time to start working on that is probably last year. That has to happen now. And then sort of final slide here, there's the bigger question that I haven't had time to get into about, if you get the money from a constitutional amendment or otherwise, how do you actually spend it? That's a whole other article that someone should write. But obviously, any program should be based on best practices and the evidence that we have on what works. I just wanted to mention real quickly that what I've seen, one of the things that concerns me is that public health language does not necessarily mean that it's actually a public health approach that's being used. So I have a doctoral student, Tamir Elsadouri, who's been writing a lot on this topic and doing some great work on that. I think that's a really important point. And then, other important point is that this might be the time where there can be some money that is put into public health and prevention. And I think if that happens, it's really important to not just focus too narrowly on opioids, but to think about the social determinants and sort of the drivers of the opioid crisis, which are sort of fueling the deaths of despair that Professor Weeks talked about, and sort of the cycle of different drug crises that we've also talked about this morning, and sort of create an infrastructure for dealing with those public health crises generally, and ideally integrating addiction care into the medical system more generally, other things that this will be the opportunity to do that, and so I think we need a lot of careful thinking about how that money can be spent. So I will leave it there. As with any crisis, this is one of my favorite cartoons. You can choose to learn the lessons from that or not. So I hope there are lessons we can take from the tobacco settlement, and also the lessons that we can take from our current time. And